We're very honored today, right, to have a colleague of mine and a friend of mine from the Ole Miss Center for Air and Space Law LLM program, right, at the University of Mississippi. This is Professor A.J. Link. We're very honored to have him on the webinar today. Professor Link received his JD from the George Washington University School of Law, and as I noted, right, his LLM from the University of Mississippi School of Law, where he studied at the Center for Air and Space Law and served as the inaugural director of the center's task force on inclusion, diversity, and equity in aerospace. Professor Link is now an adjunct professor of law at Howard University School of Law, where he teaches, of course, space law. And for those of you paying attention to such things, right, Howard University is of particular importance to the Department of Defense. Secretary of Defense Austin, just a few months ago, announced the establishment of the Air Force's first university-affiliated research center there at Howard University, the very first of these research centers to be associated with a historically Black college. Professor Link, in addition to his work at Howard University, is also the communications director for AstroAccess, as well as the research director for the Use ad Astra project. He has served as the Space Law and Policy Chair for Black in Astro and was the founding president of the National Disabled Law Students Association. In addition to his work on space-related topics, he is also a policy analyst for the Autistic Self-Advocacy Network, and he is a nationally recognized disability advocate. And so with that, it gives me great pleasure to introduce you to, right, Professor A.J. Link. Professor Link, I'll turn it over to you and start sharing your slides. Thank you so much for being here with us this morning.
Yeah, this is AJ speaking. I've got on a blue hat. It's got a lightning bolt. It's the Tampa Bay Lightning. I'm from Tampa. They're out of the Stanley Cup playoffs. I've got on a reddish shirt. It says Norma Joy. That's my partner. Today's her birthday. I know this is being recorded, so if she ever watches this, she'll know I shouted her out. And I have a beard. And behind me, there's a plant and I got some frames. I don't know how to describe those. But thank you so much, Major Grunner. Appreciate the introduction. And thank y'all so much for coming. I think I only have maybe 8 or 9 truly substantive slides. So if my math is right, we'll spend maybe 5 or 6 minutes on those. But please feel welcome to stop me. We'll actually get to that in a second. But first, I just wanted to make or bring some levity to the conversation. I think space law is cool. I think space law is fun. And I wish more people loved it. So if we go to the next slide, there's just a quick question. I don't know if y'all have access to the chat or the Q&A, but which would you rather do? Go to Luna, the moon, and come back to Earth, go on a one-way trip to Mars, or stay on Earth? Feel free to type your answers in the chat. And I just wanted to get a feel for where folks are in the room.
So AJ, I don't know if you can necessarily see the Q&A or the chat, just in case you can't, we've gotten a couple of Luna and back answers, and that seems to be the primary answer so far. Yes, several Luna and back answers.
Yeah, it's always interesting to see what the answers are in these kind of talks. So for me, just so everyone knows where I stand, I would take a one-way trip to Mars. I would happily die on Mars or in space. I'm sure that would be awful and painful. But that's where I am. And I think the reason I asked this question, or I like to ask this question, is because we all come to space with a different relationship, and we'll talk about this a little bit later. But I wish more folks understood that everyone's relationship to space is unique, even within the space industry or the space law sphere, or just in the wider public. Some people love space, some people want to stay on Earth. I actually get a lot more stay on Earth, so I like this crowd wanting to go to space. But yeah, it's really interesting to see that, and thank y'all for participating. We can go to the next slide. So I don't know why I titled this prologue. I guess it's because it's at the beginning of the chat, but please don't be afraid to stop me. Please feel free absolutely to push back on my ideas. I love that. It makes me think harder and be a little bit more in depth. Sometimes I talk fast, which I know can be hard to keep up. Happy to slow down, happy to repeat stuff. Just signal for me to do that. If you want to just stop and have time to reflect or even have a conversation, I'm really free ranging and happy to do that. Please don't feel like you're taking up my time or my space. I love having the interaction. And also ask for clarification if something I say is unclear. I think that's really important as we communicate with one another. And then some things to think about. I know Major going to talk about this. I do disability advocacy and accessibility. So thinking about this next time you do presentations, or you're doing in-person events or whatever, are you providing ASL for folks who communicate that way? Are you providing CART for folks who need captions, whether those are automated or in person, and just general accessibility stuff, right? Are we making these types of conversations available and accessible to the people who want to be there and maybe can't? I'm just seeing the comment that says, I want to leave the solar system, or at least create the chance for further generations. Yeah, that would be amazing. So with all of that said, I think we're ready to actually begin. If we can go to the next slide. So the way that this is going to go is I'm going to give a little background about how I approach the law, kind of how my education and my relationship and interaction with the law has brought me to where I am. We'll give a little bit of history, we'll talk a little bit about international law, and do a little bit of ground setting. Is that the word? Ground setting. And then we'll actually talk about human rights, space, and what the future of space governance looks like. So the first slide, and for folks who need the descriptions, my slides are just black with white text, except for the intros in the end, which were like sky things. So I think space should be accessible and inclusive for all those who wish to go, but the second part is really important, and we don't always think about that, and should do no harm to those who wish to stay. So going back to the question that I asked, no one said they wanted to stay on Earth, but lots of folks do. Lots of folks don't want to go to space. But the reverse is true, that lots of folks do want to go to space. And whether it's right or wrong, historically, space hasn't been accessible. Major Grunnett talked about my work with AstroAccess. That is an organization looking to help make space more accessible for disabled folks who want to fly, whether that's with suits or with tactile arrangements on spacecraft, or a whole bunch of other things. But it's not just accessibility in terms of disabled folks, right? When you think about where the private space industry is right now, or you think about where space tourism is going, it's really expensive and cost prohibitive, right? Pricing and affordability is another form of accessibility, but we also need to think about those historic groups who haven't had access to space. I'm thinking mostly about global South countries. I know like India is technically a global South country, and its space program is just blowing up. But thinking about those folks, how they access space, how they interact with space, I think is really important. But then the second part about do no harm, something that I'm really passionate about, it's not my area of expertise, is like the dark and quiet skies movement. I was actually just talking to folks about this the other day, who think that there's no pushback against mega constellations and things like that. And I think mega constellations can be incredibly helpful in the services that they provide, but just thinking about how we interact with space and how that affects the people who don't want to go to space, right? The next bullet point talks about the benefits of space should be shared equitably amongst all stakeholders to the greatest extent possible. I didn't have the to the greatest extent possible on one of the first drafts of these, and I got some pushback about that. And yeah, I realized that there are real struggles in terms of equitable resource sharing. I know that that's not everyone's favorite thing, right? Look at the Moon Agreement and the lack of signatories on that. But as we continue to explore space, as we are on the path to utilizing space resources, regardless of how you feel about that trajectory, are we being really accountable to ourselves and to our fellow human beings about how we're sharing those benefits, if there are any, right? Are we making sure that we're not leaving countries behind who maybe are on the same technological level or financial level to be able to get to those resources, to extract those resources, to sell and utilize those resources? I think that's something that we should always have in the back of our minds, as we're going about doing this. And then the last point on this slide is international law is not properly situated to fully address the unique environments and circumstances presented by human activity in space, but it can be a guide. And we'll talk about this a little bit later. My work with Just Add Astra, which was co-founded, created by Jonathan Lim, who I think is on this call, really got me thinking about, all the different parts of space that we aren't prepared for, right? So for those who are familiar with outer space law, you know that international law applies in space based on the Outer Space Treaty. But there are a few circumstances where international law could be a bit more specific. I know that's hard, right? If you're familiar with international law, some people ascend to it, some folks don't, right? How we interpret international law is different, but I think there are some really unique situations that could occur and probably will occur in space where international law just hasn't been fully developed yet in order to address them. But I think there are a lot of analogs that we can use. A lot of people like to use Antarctica as an analog. I'm not one of those folks, but I think there are a lot of different treaties, different aspects of international law that can help us guide and shape the type of governance systems we want to have as we continue to expand humanity's existence in our solar system. So I am ready for the next slide. Amazing. So just a historical perspective, this is the part where I kind of talk about how I've come to where I am, and we'll talk a little bit on the next slide about the last dot here. But natural law, like the law that came down from a deity or what have you, that guided human actions and human behavior and punishment and consequences for certain behaviors, right? That was like way back, right? Some people still subscribe to natural law in some forms, but that's kind of like the divine law, what's given to us. This is how it is, and there's no real, at least according to kind of natural law, human input on that, right? Human direction. But as we've moved and grown as people, as society, we've moved towards this positive law framework. And for those who are unfamiliar with positive law, I'm sure everyone on the call is, but for those who aren't, that's where law is prescriptive. Like human beings are writing law in order to tell folks how to behave, to guide their morality in a way. We're projecting our morals by prescribing laws and regulating human behavior. And then legal realism and post-realism, this is kind of where my education took me, and kind of where my law school and legal experience took me, is understanding that the law is an expression of power, not necessarily an expression of morality. That just because laws are written a certain way doesn't necessarily make them just. They can be, of course, but not always. And that we really have to examine who is crafting, writing, creating the laws. Why are they doing it? What was their intention behind it? I think for a lot of folks, I have this conversation a lot as I'm talking to folks within the legal profession, still view the law as something that is neutral and objective. But legal realism and post-realism say that that's not true, right? The law can be wielded for good or for bad. And it's crafted that way, and we kind of have to pick apart those inputs, those historical contexts, the people who were drafting them, why, the time frame they were doing it, were they looking forward? I think we'll talk about intergenerational equity later on, but that's kind of where I've gotten to. And so this slide is for me to tell y'all that I approach law from a legal realist or a post-realist perspective, and we'll talk about a few of those post-realist perspectives on the next slide. But these are just a few examples of legal realism and post-realism. There are other philosophies, schools of thought, all that, but I will go through each of these in turn. Critical race theory, for those who live in the US, has gotten a lot of buzz, I guess you could say, or attention over the past couple of years, but it actually is a school of legal thought that deconstructs the law and examines how the law has not been written neutrally and how it impacts specifically Black people in the US, but also other minoritized identities, and how the law is often viewed as a way to correct historical wrongs or right historical injustices, but it's oftentimes not enough. It's not enough for us to try to legislate morality, and it often fails. This is this is what the school of thought is. This is not like my personal perspective. But critical race theory is a legal perspective, a legal tool where you're examining who's writing the laws in the US historically, who's had the power to write the laws, who's had the power to enforce the laws, how are the laws enforced, and why does that seem to lead to disproportionate injustices, wrongs, inequalities for Black people living in the US and other minoritized folks living in the US. So the next one is feminist legal theory, similar to critical race theory, except it looks at specifically how the law has historically not been written with women. And, you know, depending on your school of feminist thought, there's lots of feminist schools of thought and lots of, you know, subsections of feminist legal theory, women and other minoritized gender identities, and that would include trans identities, non-binary identities, gender non-conforming identities, mostly under the umbrella of them presenting identities. But that is, you know, have women had input historically on writing the laws? In the US, that's mostly no. I guess historically, have the laws been written from a perspective of, you know, how it will impact women or women's thoughts, or women's thoughts, but women's behavior. How is it written in terms of providing adequate protection for women? How is it written in terms of humanizing women in the femme experience? Feminist legal theory critiques kind of all of that, and you know, says we should take pause when we're looking at how the laws were written, to see if they were actually written with gender equity and parity in mind. So expanding that beyond just the kind of US context, there is legal realism in international law. So it says TWAIL and CAIL on the slide. So TWAIL stands for Third World Approaches to International Law, and CAIL stands for Cosmopolitan Approaches to International Law. So TWAIL is, you know, as the name says, a third world, mostly global south. And like the idea of third world, I think, is kind of old now, right? Because we're not doing like first world and second world stuff, at least since the fall of the Soviet Union. But TWAIL looks at the history of international law, specifically after, you know, World War II, post World War II, and says how much input did third world or global south countries have in terms of crafting international law? How much did they get to participate in the debates? You know, were they even members of the UN or another international body at the time? Was it written from their perspective? This is really important in the context of human rights, when a lot of third world critiques say, well, the whole body of human rights law is kind of used as a hammer against developing countries and nations where, you know, richer countries, more developed countries violate human rights laws in the same or similar ways, but aren't punished the same. So the third world approach to international law critiques international law in a way that says, well, actually, these universal declarations, these universal rights aren't that universal. So something that I have focused on specifically in terms of human rights is economic, social, and cultural rights. And there's cultural deference given there, but there isn't cultural deference given in, say, civil and political rights. Like there are some, I can never say this word, I think it's non-dirigible. Someone can spell it out in the chat. So some rights don't have cultural waivers, they're absolute in terms of international law. But anyway, third world's approaches to international law say that, you know, we have to critique the way international law is written and specifically use a perspective of, you know, global south countries, third world countries, countries who have historically not been able to participate in the international law process. CAIL is a cosmopolitan approach to international law. I want to give credit to Dr. Temi Aganaba for this. I think it's she's done a good job, at least, of informing me. I'm sure other wonderful thinkers, writers, lawyers have contributed to it. But it's the idea that we should be evaluating law as one body, which sounds weird. right? It's the cosmopolitan approach to international law is the idea that, you know, we are all members of the same political entity, if you want to put it that way, the same state. So like, you know, it's not like the individual countries, the individual cities, the individual counties, local localities, but, you know, this cosmopolitan approach to how we're writing law, which is slightly in conflict with the previous universalist vision of international law that happened post World War II. And then the last one is crypt legal theory. Crypt legal theory is something that I've been fortunate enough to be a part of as kind of developing as a body of law. And it's kind of taking these same approaches and using a disabled lens. Critical disability studies is an amazing field. We won't go into like all the miles of disability and all that stuff, but it's been really informative to me in terms of how I view access to the law and the power, or I guess lack of power of the law to make things more accessible. But anyway, it approaches the law in a way that, is it written to protect and elevate disabled folks? Is it written with the input of people with disabilities in a way that make sure that their access to protected, their right to access things, their right to access spaces? You know, for me, as I've kind of worked through this in development, I view accessibility as a right, accessibility in a broad capital A sense, in your ability to be in the spaces that you want to be in. Like, we can go back to the first slide talking about, you know, if you want to go to space, is it accessible and inclusive for you? And so all of these kind of legal post-realist schools or philosophies have, I guess, treaty instruments that mirror their perspectives. So for critical race theory, there's the CERD, which is the Convention to End Racial Discrimination. For feminist legal theory, there's CEDAW, which is the Convention to End Discrimination Against Women. For Quayle and Kale, I think it's slightly different. There are a few treaties, but not specifically like, you know, about I guess reparations or acknowledging harm, but there are also declarations. But like I talked about the Moon Agreement earlier, I'm sorry that I ramble. But like the Moon Agreement, I personally think would be an example of Quayle and Kale, just because of how it's written, where it's going, the vision for the future that it has in terms of equitable sharing and making space the province of all humanity. And then for crypt legal theory, the document would be the CRPD, which is the Convention on Rights for Persons with Disabilities, people or persons with disabilities. So those kinds of schools of thought exist and can be thought of in terms of the instruments that exist at the international level, but they have also kind of informed my perspective. There are others that have informed my perspective as well. But yeah, I think we're ready for the next slide, unless there's questions or anything like that. Taking crypt legal theory and moving it to space.
Hey, AJ, real quick, we do actually have a question
Amazing.
from Mr. Mark Meyer. Mr. Meyer asks, where shall be the border between, where will the border be between maybe chemical clusters and a respected life form that we will have to treat as equal? I believe the question is referencing perhaps, right, in the space environment, to the extent that perhaps we found life somewhere out in the universe, what would be the dividing line perhaps between life that we would recognize as life and treat as such, and perhaps, you know, a conglomeration of cells or chemical clusters?
I think that's an amazing question. And something I've been working on and trying to learn from is different indigenous knowledges and how we treat sentience. You know, what's sentient, what's not, but also is sentience necessary in order to provide rights? So there are some rivers and some mountains. I want to say it's New Zealand, but also Indonesia or Malaysia, I'll have to check that, that are protected legally, that have legal rights. And I think to Mark's question, I don't know how we make that decision, I think obviously it's complicated, right? Because you have some folks who view the moon in its entirety as a deity, you know, in their religion or their spirituality. And some people on the other end of the spectrum who view it as just an absolute dead rock. And how do we make the decision? I know you're talking about, you know, clusters and small microorganisms, but how do we make that decision about how we value the celestial bodies we go to, and then how do we value the things that exist there or don't exist there, right? So there's a part of space law where it says, you know, you can't have forward contamination, which means, you know, disrupting celestial bodies. I think like if you go to celestial bodies, we're kind of contaminating it no matter what, right? But that's like up for debate. But how do we decide how much we want to disturb these places that humanity has, you know, to my knowledge, never been to, right? Some indigenous folks have a different relationship to space and space travel and things like that. But like Mark, I don't know the answer to your question. I think it's a great question. And I don't know the answer. That's not something that I'm able to answer for you. And I apologize, but I think the answer is a lot more complicated than people first take for granted. And they say like, it doesn't matter. We can just do whatever we want. So apologies if that's not a great answer for you.
AJ, additional question that we have here in the Q&A box from Mr. Wes Ferris. And it just, again, because you had said at the beginning of the chat, right, pushback, challenge, something you welcome. So Mr. Ferris says, I find the Moon Agreement to be in violation of the Universal Declaration of Human Rights, right? Of course, that foundational document with respect to human rights published out of the UN, right? And of course, signed on to by many countries around the world. He goes on and says, right, Article 17 of the Universal Declaration of Human Rights states that everyone has the right to property. The Moon Agreement, on the other hand, right, in Article 11, for example, seems to deny that right to natural persons based on this kind of equitable distribution of lunar and outer space resources that it creates. What would be your response to that?
I think that's a very good point, but I would also, not to take it too absurdly, would say that potentially the Outer Space Treaty is in conflict with that, with its prohibition on appropriation, right? I don't know how you can at least own real property. I think there's a difference, obviously, from a legal aspect between personal property and real property. I don't think you can own real property in space. I think people will. I think that appropriation is going to happen in space. If you think that it's in complete conflict, I'm open to hearing that. I don't think that the Moon Agreement is in conflict with the idea that you can have property. Like if you take something to a celestial body, I don't think anyone is going to say, well, once you leave Earth's atmosphere, once you land on a celestial body, you're no longer allowed to have real property. Or I'm sorry, personal property. And so I would say that my interpretation is that the Moon Agreement is speaking specifically about no allocation of real property, at least without some type of ownership sharing. Whereas I think personal property is slightly different.
Yeah, so AJ, next question comes from Eric M. Just to the different legal theories that you were kind of explaining on the previous slide. Eric asks, what can indigenous worldviews bring to space exploration in terms of access and indigenous values, for example, towards the space environment?
I think there's so much to offer. I'm constantly learning and still learning about how we interact with space, how we interact with nature as a whole. I think, at least for me and my perspective of current space law, there's this huge division between like life on Earth because we're here and live here, and outer space and other celestial bodies. When in reality, Earth is part of that ecosystem, you know, like we're not outside of space, we're actually sitting well within it. And I think indigenous perspectives on sustainability, on relationship to your environment, to your land, to the land, you know, for some knowledges, I think can be really informative when we're having conversations about how we want to build out our future governance structures, which, you know, I will get to, or at least I think I will get to. I hope I put that on the slide. I think including those voices is important, but not just for space exploration, but the overall relationship to space. So you think about where we build our telescopes, you think about where we build our spaceports, because lots of people are building spaceports now, where we build our launch sites. You know, who historically has owned that land or lived on that land, you know, depending on, you know, perspectives. You know, what do the treaties say in the US, like eminent domain, is that right? Talking about, you know, viewing the moon and other celestial bodies as deities, you know, how do we respect those perspectives? How do we respectfully go about exploring other people's, for lack of a better term, gods or goddesses? I think having those perspectives can help us inform how we move, how we act, how we decide we want to be human as we explore space. So I think those perspectives, and they're not a monolith, right? Like I intentionally say indigenous knowledge is, because there are different bodies of knowledge and perspectives. I think they can be incredibly informative, Eric. So I hope that answers your question.
Maybe one final question before we move on to your following slide, the slide that we have on the screen now. Jonathan Lim asks, right, how do we balance between competing human rights, right? So, of course, you addressed Mr. Ferris's question with respect to the Universal Declaration of Human Rights, all right, brought in the Outer Space Treaty, talked about those possible implications of the Moon Agreement. To the extent that we have these perhaps competing human rights, how do we balance between them?
My personal opinion is that we need to deconstruct space law. I think it's, again, this is something I said previously, it's kind of binary and bifurcated of Earth versus moon, celestial bodies, and space. I think we actually need to develop a more regional or federated system that allows for the human right of self-determination to allow folks to craft their own laws. And I will talk about that in a couple slides. So I think we can talk about crypt legal theory. I know it's like going backwards a little bit, but the reason it's a unifying perspective to kind of approach space is that it's multidimensional. And if you're interested in multidimensional theory, I first learned about it reading a book called by AFCO called Racism as Zoological Witchcraft. What multidimensionality is essentially is not an evolution or an outgrowth of intersectionality. I know lots of people like to use intersectionality now, but it's the understanding that we come to life with different experiences and different identities, and that it's not singular and that they cross-sect and intersect, but that we are multidimensional and carry these things with us. And so with disability intersects with all these other identities, right? So no matter your race, class, country of origin, gender identity, kind of all those things, all those groups have people who experience disability in some way, shape, or form within them. And so, you know, with all these other perspectives, going back to legal and post-realist, the ability for disabled folks to have the lived experience and knowledge of living with these multisectional identities, I think is really powerful. I think part of the reason that disability rights and disability justice acknowledge that, and there is a difference between disability rights and disability justice. I'm happy to go into that if folks aren't aware. But it acknowledges those multidimensional experiences of human beings. And I think, you know, this is just like me personally talking, right? It has to do with the disability rights and justice movement coming later in time than some of the other justice and liberation movements. And that's recognized within the Convention on Rights for Persons with Disabilities. It mentions how it intersects with the previous treaties that I mentioned. I think it's a wonderful treaty. World Disability Day is December 3rd for those who want to celebrate. I think that is why, for me, it's really helpful to kind of have critical legal theory as a unifying perspective to bring to space and how we craft space law. The second reason is, space is harsh. I talked about models of disability earlier from the outgrowth of the critical disability studies movement. But space is a disabling environment, and what that means in terms of critical disability studies and models of disability is it's not necessarily your physical or mental, the word in the US and the ADA is impairments or limitations, which are kind of harsh words, that make you disabled, but rather the lack of access and the environments that you are around disabling you and being disabled. So if you take that idea and extend it to space, space is incredibly harsh, right? Space is not the safest place for human beings, at least not yet. We don't even have the technology to make space safe. And so from the perspective of critical legal theory or critical disability studies, space will always be in a disabling environment, and people's disability within space will always be changing and evolving. And so having that baseline knowledge of the models of disability of critical legal theory will allow us to craft environments like our spaceships and things like that to be more accessible, but also, again, an extension, be able to craft our laws and ideas about who and what needs to be protected and how. When you think about like the right to water, like the right to access water, right? We're gonna go down to the next dot, which is accessibility framework, right? But it's just that extension of you can have rights, but do you have access to those rights? Do you have access to the legal apparatus, to the enforcement mechanism in order to make sure your rights are protected? And so going down to the accessibility framework, again, going to disability justice and Sins Invalid has the 10 principles of disability justice. You can just Google principles of disability justice, Sins Invalid, and it will come up. But one of those things is collective access. And so, again, going back to the right to access and accessibility that I was talking about earlier, for me, capital A accessibility, I think, is a good structural framework or tool to approach how we're writing and crafting laws, again, keeping in mind who has access to it. And so I want to say I've developed this concept of the right of access, but maybe someone did it before me. I just haven't read it. There's so much out there, right? But the right of access is, again, the right to access spaces, the right to access your rights. A lot of times people have rights and have no protection, so like they can't access their right, if that makes sense. And so the right to access, to me, is something that we should be writing out in our legal frameworks. We should be developing to be more coherent than what I've just said, to ensure that we're protecting people's rights in a way, to John's point about competing rights, that causes as little conflict as possible, right? So when we talk about the right to access space, that means going to space. That also means viewing space. And what does that mean for people who are promoting dark and quiet skies versus people who are building mega constellations to provide internet access, right? Is the right to the internet a human right, based on, the right to education, or another right? Like, should there even be a right to the internet? I think not, because sometimes I think I'm way too plugged in. But yeah, all that is to say that, this post-legal realist framework, post-realist framework, I'm sorry, is how I get to where we're about to go, which hopefully on the next slide is different governance structures. It's not, but I can talk about this. So John talked about competing human rights. I just want us to be clear that there are human rights and space, and there are human rights in space. So right now there's lots of human rights and space when you think about the right to privacy and remote censoring. right? When you think about your personal data and how it's stored and where the servers are and like how that interacts with satellites. And I'm not a cyber law expert. I know that we're in law and technology, but that's not my area of expertise. But there is currently real implications for human rights and space activity, right? We talk about the right to access space, but we also can talk about the right to culture and how having access to the sky conflicts with mega constellations. We can talk about, again, where we're putting our Earth-based telescopes, and are we removing indigenous people from their land? Those are, human rights. There's indigenous people's rights. That's like a third tier right in terms of human rights. So there's first tier civil and political, second tier is economic, social, and cultural, and the third tier is group and people's rights. So there are current situations that involve human rights and outer space, but not necessarily human rights and outer space. What I think John was talking about, and what Just at Astro talks about, and what we've worked on, and what I'm moving to focusing on here later in the presentation, is human rights in space, right? And in the legal community, there is some pushback, like this is science fiction, like we don't really need to talk about this right now. But I think it's really important as you hear people start to talk about colonizing space. And so for me, hearing the term colonization, going back to third world approaches and Kale approaches to international law and human rights, the history of colonization is really important. The history of decolonization and decolonial theory is really important. So should we be colonizing space, or are we migrants in space? Are we exploring in space? Even when you hear terms like space settlement, I know different people have different beliefs about how important verbiage is, right? Like some cultures have really, really dramatic histories with settlements, quite frankly. So like the language that we use informs our ideas and perspectives. You think about frontier language. I know, like, we all love Star Trek and the Final Frontier, but in the U.S. context, obviously frontierism has a different history. All of that is to say, how we go about protecting human rights in space can be brought down to a granular level with the language that we use, right? And I think human rights in space is really important, because if we're not building out those frameworks, or at least thinking about building out those frameworks now, it's going to be really difficult, especially with the impossibility of enforcement when you're hundreds of thousands of miles away. Like, what do police look like? What do our militaries look like in space? And Major Grunner will obviously know more about the militarization of space than me. But what do those things look like? What are the rules of engagement? Do the rules of engagement need to change for interactions in space? Again, do they need to be more specific, talking about international law not being fully suited to the space environment? How do the rules of engagement change when there are conflicts in space? How does humanitarian law change if the humanitarian crisis is happening on another celestial body? So these aren't problems that we have right now, and we probably won't have them for a while, but I think they are problems that probably will crop up based on human history and human conflict. And I do think it's important, not from a science fiction perspective, but from a truly legal perspective, that we have these discussions and examine the best ways to build frameworks to protect these human rights. So that was just a short, I guess, tangent on that slide.
AJ, just a couple of quick additional questions from Jonathan. First question, how can human rights enforcement mechanisms overcome space-specific challenges, right? For example, you mentioned space as a harsh environment. Jonathan references some challenges such as distance, the super celestial distances between celestial bodies or different points in interplanetary space, for example, time, isolation. And then second question from Jonathan, slightly different. How does human rights and that framework fit into the ongoing memoranda and discussion on direct ascent ASAT testing? Any thoughts on either of those questions?
John's a professional, y'all. You should connect with John. He's asking really hard questions, and I think he's actually a lot more knowledgeable than me, quite frankly. But to answer the first question, again, going back to my response to, I want to say it was the Moon Agreement question. I think federation or regionalism or something like that may be helpful in that it localizes the response, but also localizes how people are able to craft their laws and which protections they value most. I think right now the idea that the UN based on Earth or any Earth-based state or military has the ability to protect or enforce human rights is simply not possible, right? I think we have trouble enforcing human rights here on Earth terrestrially, and so I think regionalism or federation will allow for a more localized ability to, one, decide which rights those communities value through self-determination, but also again allow them for more localized and to John's point about time and distance and isolation, more acute enforcement or unfortunately non-enforcement of certain rights. And then to the ASAC question, I don't know. Anti-satellite testing is not my area of expertise. I'm not going to pretend or even attempt. I think that's a hard question, John. And if you would like to type your answer in the chat, I'm happy for Major Grunner to read that out, so folks can have a perspective on that. But I don't think I'm qualified to answer that question, unfortunately. So interplanetary human rights, the intersection between international human rights law, that's IHRL, and international space law should be filled with this new field of interplanetary human rights. And I think that interplanetary human rights should be viewed as part of the evolution of human rights. So that natural law to positive law to post-legal law. But I think it should probably be eventually a different body of law based on, how we're able to either evolve the current space law regime or, my idea to kind of break it down into smaller, more regionalized sections. And so, John, to your point, I think at least to your first question, this concept of interplanetary human rights would be really helpful in terms of enforcement mechanisms specific space challenges. I think we can go to the next slide. Yeah. So I've gotten to interplanetary law and governance through this concept of interplanetary human rights. So like I got to human rights first and I was like, international human rights doesn't seem right. Maybe we should be developing interplanetary human rights. And then as I was thinking about it, and this is where the yet from the previous slide comes in, it's like we probably need to develop a new conception of international law that is specific to larger spheres in terms of celestial bodies. And that's going to be interplanetary, for lack of a better word. I thought like intergalactic was way too what's it called, grandiose, and so we should move to interplanetary thinking, and with that we're thinking about things like participatory rights, the right against statelessness, the right to self-determination, sovereignty, which is a huge problem in terms of non-appropriation in space, right? If you think about, I think it's the Montevideo Convention that talks about the 4 things you need in order to claim sovereignty. It's like international recognition, which like will states here on Earth acknowledge or recognize a space community as being their own sovereign population. And one of the things that it requires is defined territory. And it's harder to have defined territory in space because there's no appropriation. And this is where I get to, maybe we should reconsider how we write space law. But then it's like, if we allow for appropriation, the space race is going to take on like a new meaning and things like that. I apologize for rushing through these slides, but I want to be respectful of time. Again, please stop me if you have questions or input. But that is how I've navigated from interplanetary human rights and protecting them, and some of the questions Jonathan was asking to. We probably need to develop a new interplanetary governance system in order to be more flexible, more adaptable, and more reactive to all the different types of space environments. And so I just want to take a pause and note that, like, yeah, this is really long term, that we'll have different communities on different celestial bodies. totally understand that, and I get that pushback and feedback a lot. This isn't something that we need to do right now. I just want to make that clear, but I do think it's something that we need to consider long term. So I'm ready for the next slide. So when I was talking about federation and regionalism, I think we should be developing these polycentric governance systems. So a lot of polycentric space governance now talks about involving private industry and civil society, and polycentric in that way. When I'm talking about polycentric governance, I'm thinking about more centers of governance and legal institutionalism or authority. So whether that is like the Earth and Luna is one region, right, and Mars is one region, and the intercelestial space between them is, like international waters currently. I don't really like that analogy, but something like that, right? That is more what I'm thinking of, and that can be federalism. Like here in the US, obviously we have a federal structure where there are state governments and then a national government. Maybe that's something like that. Again, using Earth and Luna as example, maybe Earth and Luna have their own separate local governance structures, but then we have a unified governance structure for both of those. You've got regionalism, which is going to be like the African Union or the EU, where states are kind of ascending to be governed by a singular economic or political system. And then you have things like supranationalism, which is like the UN. So like maybe the UN, not to be too science fiction, but maybe it's something like The Expanse, where like the UN is like the government, speaking for Earth to other entities. So I think these are kind of different ideas in terms of how we can deconstruct space law into more localized regions and allow for that self-determination, political participation on larger government bodies. One thing I will just go back to on political participation, I think it's going to be a really interesting question, how people have political participation during elections and stuff when they're in space. I know it's happened before in the US, and they voted in Texas because that's where they launched from. But I think that might be something that's really interesting moving forward too, as as citizens of states or countries here on Earth, how do you participate in elections safely, securely while you're in space, or do you get to it all? So sorry for that random backtrack, but yeah, that's something to think about too. I think we're almost done. Next slide. Yeah, cool. So outer space is a realm of possibility. I think we can develop it into a way that is inclusive and accessible for everyone who wants to go, but also super protective of those who don't. I know a lot of pushback that I get from folks outside of the space community is space just for the rich folks, and they're going to abandon all the poor people to space once climate change happens or there's like global destruction. I think it's like what's the movie, Don't Look Up or something like that. Making it accessible for everyone who wants to go, but also protecting those who want to stay on Earth and have an attachment and affinity for being here on Earth. And I think a new interplanetary framework will be necessary in order to maintain peace and stability beyond Earth, especially as we start to have more humans in space, in different parts of space, in the space-time continuum. So that is my presentation. I think we have 4 minutes. Is it 4 minutes or 19? Do we have a hard stop at the top of the hour?
Yeah, so AJ, no hard stop as long as you have personal time, right, to extend perhaps beyond 9 o'clock for questions and things. Certainly, right, for our attendees, feel free to jump off whenever you need to. But yeah, we'll continue the conversation for as long as, right, perhaps there are questions to be asked. And so first, AJ, I just wanted to thank you so much for your time today. I liked this conversation for a lot of reasons. One of the reasons is because it's perfectly timed to coincide with kind of the end of my space law class here at the US Air Force Academy. And several of my students wrote about the issue of space tourism, and a number of them noted, right, some of the issues that you raised with respect to, for lack of a better word, right, the exclusivity of that activity, right, as it is right now, both in terms of the cost and both in terms of, right, the the physical abilities of the people, right, who currently are able to access space in that way. And so as you were discussing those issues, right, I thought to some of the essays that I've been reading over the last couple of days, and I think it's a very valuable topic. So thank you for that. I also just wanted to note for our listening audience that some of the topics that Professor Link has discussed today can be found and discussed in a variety of readings. One very good book that addresses some of these issues is this one, published by Springer. There we go. Commercial and Military Uses of Outer Space. It's edited by Melissa Deswart and Stacy Henderson, and it discusses some of these different kind of legal theories, applications of indigenous rights, right, to the space domain and to kind of space terrestrial infrastructure. And the book itself, once again, to kind of reference Professor Link's various legal theories, is written by a panoply of all female authors, right? So a very interesting read published by Springer. No federal endorsement, but it is a very good book. Now, let's turn back to Q&A. So sorry to kind of take that aside, AJ. One of the questions that I was kind of thinking of, specifically based on your discussion of kind of critical disability theory that you've been discussing, one of my colleagues not overly long ago hosted a webinar with the underlying topic of genetic modification, all right, for individuals who are potentially going into the space environment, right? And so I'm sure that this is a topic perhaps that you are somewhat familiar with, right? This idea that human beings could be genetically modified in a variety of ways, right, to better survive perhaps in the space environment. From maybe a critical disability standpoint, and right, your discussions of access to space, what is your opinion of this kind of genetic modification idea? Obviously, this seems to be perhaps an affront of sorts, right, to individuals who have different abilities. What are your thoughts?
That's a tough question. I think I will localize it to a solid understanding of like temporary or small modification, not like posthumanism, which is just a wild concept. I think part of that idea is rooted in this concept called techno-chauvinism, which I do a little bit of AI work, but it's like this concept that technology will always save us. And it discounts the idea of how adaptable human bodies can be, not on a large term evolutionary scale, but the ability for the human body to adapt, like which goes back to it being disabling, right? But you know, if I forgot which astronaut it was who was on the International Space Station for like 6 or 9 months and they shrunk 2 inches or something like that. Like our bodies will change and develop. And I don't think it's a good idea to kind of preemptively stop that change because we don't know the negative effects of that. When you talk about how it interacts with disability, I think we have to unfortunately talk about the idea of eugenics, not negative eugenics, but positive eugenics, and that we want to breed or cultivate a specific type of body mind. And I think we don't have the information right now to know what's the best kind, what's the best way. I think one of the important things for me in terms of space exploration and making it accessible is there are all different types of body mind types there, and we don't really know which one is best suited for long-term space habitation, right? Maybe I use this example a lot. Maybe introverts are better suited for long-term space missions because they like being alone and quiet and keeping to themselves, where an extrovert may have or develop mental health disabilities because of that isolation, like a lot of people did in the pandemic and really struggled with that. That's just a really easy and common example for me to use. But I think the idea that we have to genetically modify human bodies in order to thrive in space discounts the amazingness of human life and experience. I think once we have enough information, maybe, right? If we have the technology, if people aren't coerced into doing it, if they have the free will to decide for themselves, where it's not like, well, you can't go to space unless you have this modification. I think there's potential there, but I think that's a long way away. And I would give caution reservation to the idea that having genetic modifications will save humanity or better prepare humanity.
Awesome, thank you. And I noticed that Jonathan has posted a comment about genetic modification. He just said, genetic modification and eugenics must be distinguished, but both present significant challenges to realizing common dignity and equality. Different healthcare requirements arising as a post-genetic aftermath strains the realization of the right to health.
I would agree.
Excellent. Thank you, Jonathan, for that comment. AJ, a slightly different question. So in terms of the kind of interplanetary government, that governance that is to some degree the subject of the talk today, one of the things that I was curious about when you were discussing the sort of different legal theories kind of midway through the presentation, I'm going to ask you a question perhaps that's maybe more military oriented, which I know, is not necessarily your area of expertise, but I think it can be expanded perhaps to different areas of outer space kind of subtopics. So my question is this, So when you're thinking about perhaps these kind of third world, for lack of a better term, legal perspectives, we certainly saw during the development of outer space law and the development of the Outer Space Treaty, some very strong opinions from certain nations within the global south, and thinking perhaps India, towards ideas regarding the peaceful uses of outer space, Peaceful uses of outer space, something, of course, that's very significant to us in the US military, just from a military perspective. It seems, though, that perhaps some of these global South nations, and again, I'm thinking of India because their perspective on this has evolved, since the 1960s, have been influenced, to change their perspective on some of these issues. And so, for example, India is now much more willing to use and utilize outer space for limited military purposes, perhaps. What are your thoughts on the way in which perhaps larger spacefaring countries, the United States, the Soviet Union, maybe now the People's Republic of China or the European Union kind of collectively, how are the perspectives of these spacefaring states affecting, the perspectives of maybe states in the global South towards certain space-related topics, such as the peaceful uses of outer space?
My realist answer, my not legal realism, but realist perspective is space isn't going to be peaceful, unfortunately. I think if we're realistic, it's only a matter of time before conflict, whether it's remote and cyber is already happening, or physical, for lack of a better term, or kinetic engagement happens, it's only a matter of time. And I think we've developed space law, space activity, and space industry in such a way that it's bound to happen. I think how it happens, how we define those rules of engagement, again, going back to maybe space law isn't necessarily adequate enough. Sorry if you can hear that siren. Isn't adequate enough to handle that. And so a lot of countries interpret peaceful purposes as we can use force to protect peace, or force to, and not to be redundant, enforce peace. And I think the idea that there will be no conflict or no use of force in space is wrong, quite frankly. I think it's going to happen. I think what we have to do as we're developing our technologies, our abilities to be in space, to navigate space, to have different space forces, because the US isn't the only country with a space force, I know a lot of countries have aerospace forces, I think is what they call it. That's like it's the same thing. That's what the US had before the Space Force separated out. What are the rules of engagement? I don't know. I know someone has recently published a book on engagement in space. If y'all want to go pick that out, I'll let Major Grunner tell you who wrote that book and who published it. But I think that's a really difficult question, quite frankly. And again, going back to, we probably have to deconstruct current space law. I think that's part of the reason why is like we have these lofty ideas and ambitions, but I think real world application, and I guess we're off that. So real space application is vastly different. And, you know, are we just going to say everyone's in violation of the international law? Or are we going to admit that the international law has failed and we need to change it?
All right, I'm looking through the chat here, AJ. So Jonathan had a brief question about human right to healthy environment. I think to some degree, maybe you discussed that a bit when you were talking about the nature of the space environment itself. Any final comments on that?
I think the human right to a healthy environment will probably have to be one of those rights that's dirigible instead of non-dirigible, because it's going to be really hard to define what exactly healthy is and not is. Sorry if that didn't come off clearly. I think it's a good idea to, and Jonathan's written about this, quite frankly, is way more articulate about it again than I am. I think the idea that human beings should be able to be protected from things like microgravity or radiation is really important. How we write that law, how we enshrine it, how we enforce it, I think is the difficult part, right? And it goes back to a right to access. We can have a right to a healthy environment, a right to be free of certain radiation, but how do we access that right? How do we build spacecraft, space suits, space communities, space environments on celestial bodies in order to protect humans from that? I think it is the more difficult question. Should there be a right to a healthy environment? I mean, yeah, if we can define healthy and then to figure out how to give people access to that.
Awesome. And then one final question just for me, since I see that we don't have anything remaining in the chat box. So we've seen kind of recently, right, a number of attempts to perhaps further develop space law, right? And some of these attempts have stalled, and some of them seem to be somewhat ongoing, right? And we have a generally maybe kind of a binary concept between maybe certain states or groups of states that want to develop maybe additional treaties and binding space law. We've seen, on the other hand, right, maybe attempts to develop what are traditionally known as maybe norms of responsible behavior, tenets of responsible behavior. What are your thoughts on these methods of developing space law, and what would be your thoughts as to how maybe these different strains of ideas for developing space law could contribute to these issues of interplanetary governance that you've discussed today?
Yeah, I think norms are going to win out right now. I think we're seeing that with the Artemis Accords, the push for norms, because people don't want the restrictions of hard law right now. And I think that's fair. I think the idea that although international space law is really flexible and allows states to have different interpretations of it at the national level in terms of their national space law, it is restrictive, I think, for what folks want to do. I know that a lot of people in the space community are afraid of opening up the treaties and trying to change them. One, because it'll be really hard to get consensus, which is what COPUOS 1's on. But two, because of the potential harms and violations, which I think are fair concerns. But, you know, going back to the entire presentation, right, like eventually we're going to need a bit more flexibility. And I think that's going to take, you know, deconstructing the current space law, whether that's, you know, folks removing themselves from treaties like Saudi Arabia recently. I don't know the technical term, it's escaping me, like took themselves off the moon agreement, right? Whatever that means. Maybe that's going to happen with larger space law. I don't think that will happen soon, but it could get to the point where it is, where like a country is like, we have so many valuable assets on these celestial bodies that we have to claim the territory. Whether that's right or wrong, whether, you know, they have the right to claim those valuable assets and resources. I think we're going to get to that point. And so what are people going to do? Say like, you're in violation of the outer space treaty, and the country is like, okay, well, take us off, or are they going to like renegotiate it? I think there are some really serious concerns that are going to develop simply because the way that we interact with space, I think, is just so far beyond what the original treaties could imagine, quite frankly.
Well, Professor Ling, thank you so much for your time this morning. Since we are about 13 minutes after the hour, I do see that like a good number of people have stayed on to listen to the Q&A discussion. So thank you to all of our attendees, right, for being here. AJ, do you have any final closing thoughts before the end of the webinar today?
Thank you. I really appreciate this. I know that, everyone has lives and things to do, so I really appreciate folks coming. Major Gunner, I just appreciate you having me. This is something I'm really passionate about. I really care about. I wish I could do space law more regularly as my full-time day job. Maybe one day we'll get there. But I think, going back to something I said earlier, it's really important not for us to build these systems now, but to start having serious conversations and not to shoo them off as science fiction or too far away, because before you know it, like, we were doing these activities and like we don't have the laws, and building laws as things are happening, it's kind of dangerous if you have any experience with law. And to your last question, the norms may be there, but norms are easily violated until they become customary law, and you can have at least the threat of enforcement, if not the actual ability of enforcement. So I'm just saying thank y'all so much for caring about this. It's something that I care about, something I think about all day, every day. So just thank y'all. I really appreciate the time and the platform. So thank you, Major Gruner.